Hello, we are here today to talk about some different fact scenarios about when U.S. citizen children who are 21 years or older can petition their parents.
Okay. Allison, let's say I'm a United States citizen and I want to petition a parent that happened to enter the United States lawfully, but they overstayed their visa. What are their options to obtain a green card?
So in that scenario is what I would technically call a best case scenario. Parents of U.S. citizens who are 21 years or older are called immediate relatives. That means there is a visa immediately available for them as soon as the child can petition, and that means that certain violations of immigration law, for example, overstaying a visa and working without authorization, are automatically forgiven. So they would be eligible to file their adjustment of status residency application here in the United States. Of course, with that scenario, they should still consult with an immigration attorney to make sure there's no other grounds of inadmissibility or issues that happened either when they applied for the visa or while they were here in the United States. But generally speaking, for the most part, that person would be eligible to file the adjustment of status.
Let's say the situation is a little bit differently. Let's say that my parent entered unlawfully. What are their options then to obtain a green card?
So entered unlawfully, you mean without inspection?
Yes, without inspection.
So by entering unlawfully, we're typically talking about an entry without inspection or an iwi entry across a border. When that happens, the law is very different. And unfortunately, that person would not be eligible to adjust status or file for residency here because they need to return to their home country and file through the consulate in their home country to have a lawful entry. The issue then becomes, although their child can physically file the petition for them, they're going to have other issues or other grounds of inadmissibility or being ineligible for the residency in a different way. The biggest issue comparing these two situations is the moment that someone leaves the country to file for residency, they trigger a 10-year bar for their unlawful presence for all of the years that they lived here without status. There is a waiver that exists for that bar, but not when your only qualifying relative is your child. So in that scenario, unfortunately, if the only qualifying relative or person in the United States with status is your child, you're not going to qualify for the waiver, and you will have to wait out that 10-year bar outside the country before you're eligible to return with the green card status.
Okay. Let's say that my parent entered unlawfully without inspection multiple times. What are their opportunities then to adjust?
So what might have happened in that scenario is they've triggered what's called the permanent bar. So the permanent bar can be triggered in two ways. One is if they enter unlawfully or are here without status, meaning their visa expired for more than 1 year, then they depart the United States and re-enter again without inspection at any time. Or it can be triggered if they've ever been physically deported or ordered deported or removed from the country. They depart the country and they re-enter at any time. When you have the permanent bar, it means exactly what it says. You are permanently ineligible for residency or any other sort of status. The only way around it is, again, if you leave the country, spend 10 years outside of the United States, and then you can apply for permission to re-enter. There is a difference between the 10-year unlawful presence bar I just described and this permanent bar, though, and that the unlawful presence bar is waivable at any time if you have a qualifying relative, whereas the permanent bar is only waivable after you've spent 10 years outside of the country. In any event, if you do have a child about to turn 21 or who's already 21, we urge you to come in and see us for a consultation so we can talk about the specifics of your case and what options you may have moving forward.